Members, good morning. It's the appointed time and we have a quorum. I call to order the meeting of the panel on manpower. Agenda item number 1, information papers issued since the meeting on the 19th of December 2023. There are two sets of members that have been circulated to members by the Secretariat. They are CB bracket 2 11 stroke 2024 bracket 01 and CB bracket 2 182/2024 bracket 01. They are information paper provided by the administration entitled Implementation of the Mandatory Provident Fund System, Progress Report December 2023 and January 2024. Please note that. The next agenda item is the items for discussion at the next meeting. May I invite the government officials to enter? The Secretariat sent two sets of paper to members. They are the list of outstanding items for discussion, LC paper number CB bracket 2 190/2024 bracket 01, and a list of follow-up actions, LPC paper number CB bracket 2 190/2024 bracket 02. On the 6th of February, Mr. Ngan, Deputy Chairman, and myself had a meeting with the Secretary for Labor and Welfare. We relayed the items proposed by members in the last meeting to the Secretary for Labor and Welfare. We have considered a host of factors and we have come up with a list of outstanding items for discussion. Please refer to that. The next meeting will be held on the 23rd of March 2024. There are two items of discussion. They are the review of the continuous contract requirement under the Employment Ordinance and the processing of applications to the Protection of Wages Insolvency Fund in 2023. Please note, if you agree to the proposed items of discussion, the meeting in March will be held for 2 hours. Now we move on to the agenda proper. They are the measures to foster harmonious labor relations by the Labor Department. The Secretariat has prepared a set of documents for members. Mr. Kwok Wai-kun, Mr. Luk Chung-hong, Mr. Dennis Lang, and Mr. Kingsley Wong, in accordance with Rule 822 bracket P of the House Rules, submitted a motion for this agenda item. The wordings has been sent to members. They are set out in LC paper CB bracket 2 216/2024 bracket 01. If members agree that we should process the motion before we conclude this agenda item, I will process the motion by inviting members to vote. All agreed? With us today from the government are Mr. Raymond Ho, Deputy Commissioner for Labor, Labor Administration, Mr. Raymond Liang, Assistant Commissioner for Labor, Labor Relations, and Mr. Ma Kwok-kun, Chief Labor Officer, Labor Relations. If you would like to speak on this item, please press the button. Now may I invite a representative from the Labor and Welfare Bureau. Do you have a presentation or should we start the Q&A session right away? Deputy Commissioner, please. Thank you. Good morning. Here, we would like to report to members on the measures to foster harmonious labor relations by the Labor Department. As set out in the paper, we take forward the task from 4 different angles. They are publicity, proactive intervention, consultation service, and conciliation service. We want to maintain a harmonious labor relations in Hong Kong in terms of publicity through different channels. We hope to let the employers and employees understand the obligations as stipulated in the Employment Ordinance. along with their rights. We think that if they understand the employment ordinance, we can stop disputes at source. If members of the public would like to know more about the ordinance, we have a website, we have a hotline and an email for people to lodge inquiries, and we also have 10 branch offices for people to do so. The Labor Relations Division regarding specific groups, including imported labor and foreign domestic helper. And for those who are not aware of their status of employment, we have in-depth consultation service provided to them. We have a list of inquiries to let people know about their rights, to see if they are being exploited, and we help them to define the status of their employment. The Labor Relations Division work with different stakeholders and employers regularly, and we take a proactive approach to intervene into labor disputes before they even arise. We provide necessary advice to employers and employees. There are labor-related cases in relation to retrenchment and changes in employment or variation of terms of employment. We provide advice to employers and employees so that no labor disputes would arise. If labor disputes do arise, we provide conciliation service. We act as a middleman, and we take into account the facts of the case to help employers and employees to reach a settlement. About 70% of cases are resolved through conciliation by our department. If the case cannot be resolved by conciliation, depending on the sum of claimant and a number of claimants, we will refer the claimants to the Labor Tribunal or the Minor Employment Claims Adjudication Board. If liquidation or bankruptcy is involved, we refer the employer or employee to the Protection of Wages on Insolvency Fund. If the employer is suspected of breaches of ordinances, we will refer the case to relevant divisions for criminal investigations. Here are work. Thank you. We want to maintain a harmonious relationships between employers and employees in Hong Kong. There are 6 members who have pressed the button to speak. First, Professor Chen Wei-Kong, and then Mr. Tommy Cheng, Mr. Chu Kwok-kun, Mr. Kwong Wat-kun, Mr. Kingsley Wong, and myself. 4 minutes, including question and answers. Professor Chen. Thank you, Chairman. I'm pleased to see that the government is adopting measures to foster harmonious labor relations. A good labor relations can enhance efficiency and results. But I think that the government is taking a rather conservative approach. They only do proactive intervention and consultation services. But it seems that they are not proactively trying to curb labor disputes. Are you trying to maintain a fair labor relations so that we can avoid labor disputes? According to paragraph 10 of the paper, it says that the LRD provide consultation meetings and labor disputes and claimed the number have increased by about 14% as compared with that of 2022. Is it because the work of the department is not as effective? That is why the number is stagnant. Thank you. Thank you for your question. Apart from the tasks that I mentioned, including consultation service, productive intervention, and publicity, We also foster direct communication between employers and employees. We do have a dedicated task to handle that. We try to encourage employers and employees to communicate directly on labor matters. We provide assistance in the course of that. We think that labor relations are harmonious in Hong Kong overall. The number of lost working days due to labor disputes is 0 over the past 2 years. So we think that that is a good thing. Maybe I invite Mr. Ma to talk about the number of consultation meetings as set out in the paper. In 2023, the number is higher than that of 2022. We've looked at the reason. That's because in the first half of 2022, the economic activities in Hong Kong were still impacted by the COVID. But in 2023, the economy has resumed normal and there are more business or economic activities. That is why the number of labor disputes and claims have returned to pre-pandemic level. The number of labor disputes and claims are indicators, but it does not mean that the number signify the status of labor relations in Hong Kong. We will closely monitor the situation, as mentioned by the Deputy Commissioner. We will continue to collect data and we will try to avoid labor disputes from happening. Thank you. Mr. Tommy Cheng. Chairman, I've been an employer in Hong Kong for decades, and I've not gone to the labor tribunal too many times, but I've never lost to my employees. As an employer, well, before I joined the Legislative Council, I've met with your secretary. I asked the Labor Department to be more neutral in the case handling. Sometimes the employees are at fault, but I was asked to make compensation. When I refuse to do so, they take the case to the Labor Tribunal. I'm not asking the department to help me, but I was just asking them to stay neutral. You would never guess what the Secretary of Labor told me. He pointed to the plaque of the Labor Department. He said that our department is called the Labor Department, not the Employer Department. That is why they should help the labor instead. And they should ask the employer to compensate, even when the employees are at fault. To foster harmonious labor relations, you may have to change the name of your department so that you can stay neutral. Well, the said secretary is still here, and he is probably my age. He may have forgotten what he said back then, but I clearly remember that. If you want to foster harmonious labor relations, the department have to be neutral. And you should not just refer all the cases to the Labor Tribunal. I hope that the Labor Department will stay neutral and try not to tilt in favor of any parties. If the employees are at fault, you should tell them, and vice versa. If the employers are at fault, maybe you should ask them to amend their manual and so on, and guidelines, for example. I don't think you have the power to change the name of the Labor Department, but if you can do that, that will foster harmonious labor relations.
Chairman, I need to rush to the EXCO meeting in a moment, so if you can let me finish my speech. I don't have any AOB or anything against the motion. But do we really need to expand the functions of the Labor Advisory Bureau? The Liberal Party has always said that anything that passes the LAB, we will support it even if we don't perfectly like it, and that includes a 468 arrangement recently. The LAB is there to sort out issues involving workers, employers. It's best to sort things out at the LAB. It's best to sort things out during the discussion there. Now, on the impartiality of the Labor Department and the LAB's functions, Deputy Commissioner. I thank Mr. Cheung for his comment. I fully agree with him on one point. The conciliation officers need to stay neutral and act based on the facts of each case and also act on the terms of the employment contract and then give advice to employees and employers. Mr. Chu Kwok-keung. Thank you, Chairman. The LD has different measures to help workers and employers sort out problems and work out differences. But the work is restricted to what's within the framework of the employment ordinance. But issues arise in gray areas, such as overtime work. The employee has accumulated leave days, but the employer refuses to let the worker take leave or even dismisses the worker. Does the worker get paid for the untaken leave? That may not be spelled out in the employment contract. And the EO employment ordinance does not have express provisions, and then disputes arise. So given all the cases, all the data the Labor Department has, is there a mechanism to update the EO regularly to plug those loopholes? Deputy Commissioner. Thank you. Conciliation at the Labor Department is based on the Employment Ordinance and the Minimum Wage Ordinance. The conciliation also deals with claims and other matters, say compensation for overtime work. Issues over overtime pay are also covered by conciliation. When workers and employers disagree over certain arrangements, we also provide advice. We provide advisory services to help workers and employers sort out the problems. Mr. Chu Kwok-keung, follow-up questions from you? No? Let's move on to Mr. Kwok Wai-keung. Thank you, Chairman. Excuse me for my hoarse voice, and I might take a bit of time. One point about the LAB, the Labor Advisory Board, it's advisory in nature. It has no real power. There was a major incident. It's about the construction and the transport industry, the special labor importation schemes. The import schemes did not go through the LAB for its advice. So stakeholders slammed this idea, and the LAB came under pressure. So what measures will the department take to raise the credibility of the LAB and raise the LAB's profile so that the LAB can continue to play its role in labor issues? There were past labor issues The employment relationship was what mattered above all, but now there are gig workers, they workers on digital platforms. Their employment status is unclear. So for the rights of these digital platform workers, we need to protect their rights. If no employment status is established, can we have a tripartite consultative mechanism to protect these workers' rights so that these workers will be better aware of their rights? Thank you. So the questions have to do with the LAB's functions and self-employed or sham self-employment. Deputy Commissioner. I thank Mr. Kwok for his comments. The Labor Advisory Board is a key institution for tripartite consultation. The government values the functions of the LAB. So anything to do with changes to the labor law, the matter is discussed at the LAB first. Now on labor importation schemes. Labor importation is something with implications for the community as a whole. So the decision is decided on at the Executive Council because labor importation has to do with the entire economy, our social development. We value the function of the LAB. We have the enhanced labor importation scheme. For each application, we consult the LAB. Now, for industries, every 6 months, we update the LAB on the industry-specific labor importation schemes. We also value the comments from the LAB on how we should proceed with the schemes. Now, on tripartite consultation for workers of digital platforms. In December last year, we updated the panel on this matter. The Labor Department set up a liaison group involving digital platforms. We're considering that maybe later this year, our direction is to get labor group, workers group to get involved. We hope that this liaison group can help follow up on the matters. Thank you, Chairman. Mr. Kwok's question is this. Workers on digital platforms are employees, but they are treated as self-employed workers. So are there ways to protect their rights? Now, on protection of rights, we will continue to work on that. Our existing work includes territory-wide household surveys. We will also listen to the views of workers of digital platforms. We will also look at our directions, that is, on how to ensure better protection for workers on digital platforms. Mr. Kingsley Wong. Thank you, Chairman. I thank Legislative Secretariat for its study on tripartite consultation systems in Hong Kong. It's hard to reach consensus on labor issues. Singapore is doing well. And that's because of the leadership offered by the Singaporean government. The government there offers good leadership. Over here in Hong Kong, we discuss policies too, but let's look at Singapore. They have guidelines on wage adjustments and labor rights protection. They can reach consensus in Singapore, but let's look at Hong Kong. Let's look at our LAB. The government is not playing a proactive role in Hong Kong. The matter is left to employers and workers. The government stays in the background. Employers are in a strong position. Workers are in a weak position. It's David and Goliath. We're not asking the government to favor anyone. We're asking the government to be this impartial, to keep a level playing field. So in the future, in a tripartite system, how can the government play a greater role and ensure a level playing field instead of just letting employers and workers sort out issues? President Xi Jinping said that let's talk things out, especially when it's something with public implications. We need to drive a consultative culture. Some industries are importing workers. Let's look at the Transport and Logistics Bureau. The TLB is not active in talking to labor unions before importing labor minibuses, again, imported workers. Can they be more proactive in talking to trade unions? Practice varies, the mindset varies from one department to the next. So for the Labor Department, can it review the practice of different bureaus and departments? For labor relations, government departments need to talk to trade unions on an equal footing. Trade unions told me it's like superiors talking to their subordinates instead of departments talking to trade unions as equal partners. Has the LD promoted this kind of culture, a culture of equal partnership? Can we have this kind of culture within the government? So the questions have to do with tripartite mechanisms, talking about wages, and a culture of equal partnership. Deputy Commissioner, please. I thank Mr. Wong for his comment. Different places have different labor tripartite mechanisms due to their own history. In Hong Kong, we have a three-tiered system. At the LAB, Labor Advisory Bureau, that's the highest level. At the industry level, there are tripartite bodies. Within companies, we encourage companies to talk to their workers and unions over employment matters. In Hong Kong, we keep enhancing our labor legislation to offer better protection for workers. There are different pieces of legislation, but the legislation is there to provide a floor, a minimum level of rights. Our approach is to keep improving the legislation, and we manage to implement changes to give workers protection. And on that basis, we encourage employers to go higher than the statutory minimum of rights. We encourage employers to give workers better benefits. So that's our system. For sure, we will continue to take the three-tiered approach, LAB, industry-specific bodies, and at company level, we encourage consultation. Mr. Kingsley Wong mentioned the industry-specific labor importation schemes. From what I know, there is the Construction Industry Council. They have a task force with labor side involvement to keep an eye on their industry-specific labor import scheme. For the transport sector, there is consultation in that sector. There's a mechanism for that. There is involvement of trade unions too. So the government continues to value the input from employees, workers.
I have a follow-up question. The Development Bureau is doing well in this regard, so I hope that the Deputy Commissioner will talk to them. We should encourage this culture of conciliation. Anything to add from the Deputy Commissioner? No. Mr. Tang Fei. Thank you, Chairman. According to the paper provided by the administration, they talked about tripartite committee, but they don't have much data provided, so I have to refer to the paper prepared by the Secretariat. For the free of charge conciliation service, what is the percentage of success? It says in the paper that in 2022, over 70% of the cases have been resolved. Now we are in 2024, so I would like to ask about the numbers in 2023. Is the 70% an average figure? That's my first number. If the case cannot be resolved through conciliation, the case will be referred to Minor Employment Claims Adjudication Board for adjudication. So my question, or second question, is this. How long after the conciliation will you consider it a failure? I think that the conciliation cannot be settled by one meeting. So at what time should we ask the claimants to go to the Labor Tribunal or the Minor Employment Claims Adjudication Board, MECAB? The requirements or threshold of these MECAB is not that high. The case should not consist of more than 10 claimants, and the claims asked by each claimant should not exceed $15,000. So the workload of this MECAB is not light. $15,000 is less than a month's salary, I believe. If the case is consisting or amounting to such a small sum of amount, MECB have to handle them, so I am worried about their workload. Thank you. Maybe I invite the Chief Labor Officer, Mr. Ma, to talk about the conciliation service, and then Assistant Commissioner will talk about the cases handled by MECB. Thank you. Mr. Ma, please. Thank you for your question. The member asked the number of cases resolved by the Labor Department in 2023. There are over 70% of labor disputes and claims with conciliation provided by LRD resolved. We look at the number of cases that we handled in a year and the number of cases that have been resolved. We compare the two figures and come up with this percentage of resolved cases. And the member asked when we will take the case to the court. We don't have a rigid standard for that. We don't just look at the number of meetings we have convened with the claimants and claimees. For some cases, we have to have 5 to 6 meetings before we decide on the status. Some cases can be handled through phone calls. If all parties fail to reach a settlement through conciliation, the cases are referred to Labor Tribunal and MECAB. When that happens, the cost involved would be significant. So we try to resolve disputes at the LRD level. For the cases that go to the Labor Tribunal or MECAB, those are more serious ones. Would Mr. Lian talk about the MECAB and the cases that they process? Thank you. Mr. Tan said that MECAB is being mentioned in the paper provided by the Secretariat. If the cases cannot be resolved by conciliation, services provided by the LRD, the cases can be referred to MECAB on top of other bodies. Under a conciliation mechanism, if the case cannot be settled, claimants can, according to the number of claimants and the sum involved, go to Labor Tribunal or MECAB for adjudication. The difference between these two ways of settlement are the number of claimants and the claim amount. For cases handled by Labor Tribunal or MECAB, the sum should be less than $15,000 and the number of claimants should be less than 10. If the numbers exceed the figures that I mentioned, the case should be referred to Labor Tribunal instead. Here, I would like to follow up on the threshold of $15,000 per claimant. I think that the number used to be $8,000. So I would like to ask if there is a mechanism for adjustment. Thank you, Chairman. You are correct. The $15,000 was amended in 17th of September 2021. The figure used to be $8,000. Why we adjusted the figure? The $8,000 threshold was set in 1997. We've taken a look at the claim amount in the cases that we have handled. We think that the amount is too low, and that is why we saw a need to make adjustment. In 2021, the adjustment was passed in the Legislative Council. So when will we further adjust the amount upward? We will have to look at the situation because we have not adjusted the amount for a long time. Every year we handle some 500 cases. In 2023, we handled more than 1,000 cases compared to 500 in 2021. So we have to look at the workload of our colleagues to see if we should adjust the amount. Thank you. I hope that the Labor Department will review the wage level in the community and try to review the threshold from time to time. Thank you. Next, Mr. Dennis Lin. Thank you, Chairman. I would like to thank the Labor Department and the colleagues from the Labor Relations Department for their work. Some district officers were very helpful in handling labor disputes. As mentioned by other members, I hope that the government will play a more proactive role. Mr. Tommy Cheng is a good employer. We want to target employers who act in bad faith, who break the law. I hope that the government will step up enforcement effort in combating illegal acts or exploitation of workers. I hope that the government would note this. When the Labor Department is handling labor disputes, it seems that the staff of the Labor Department is not as well versed in the labor-related ordinances. When the outsourced workers cannot renew their contract, including those who work for the housing department and so on, we ask the employers why they ask the employees to sign the voluntary termination of contract. And the employers of the outsourcing companies told us that the Labor Department asked them to issue such a paper for the employees to sign. The voluntary termination of contract was signed by employees, and they were asked by their employers to do so. And we think that that is a malpractice. Second, there were employees who need to seek wages that are on default. If the employers file for liquidation or bankruptcy and they are unable to pay their employees' wages for 6 months, the employees cannot seek application from the protection of wages on insolvency fund. The fund involved is some $200,000 to $400,000. So there is a time factor involved. So I think that you need to retrain or train your staff. We need to provide more information to the employers. I think that the colleagues from your department should be well versed in employment ordinance. Thank you. Thank you for your comment on the services provided by LRD. For consultation services or conciliation services, the colleagues providing those services should be well versed in their relevant knowledge, and we will continue to train our staff. And they should be providing quality service, and I agree with that. We will step up education and training. If you have cases that you are handling, please let us know. As for the time barred element of the PWIF, we have improved the arrangement. As long as the employee signs some forms at our office, we consider the application made. If you have any such cases at hand, please refer them to us. And if you have any names of our colleagues, we will note that and we will try to talk to the relevant colleague. Mr. Lang, if you have any cases at hand that are not handled well, please refer them to the Labor Department so that they can follow up. Thank you. Mr. Lok Chung-hong. Thank you, Chairman. What is the nature of labor relations? Is the sharing of the fruits of labor. Everyone wants to take a bigger pie. Employers put in little effort and they want to enjoy more benefits. And from the employees' perspective, they also want to enjoy the fruit of their labor. There is a conflict. But there is also a symbiosis element. This is a philosophical question. If Mr. Ho, Secretary for Labor and Welfare, is here, I will talk to him about this dialectical materialism theories. I think that the Policy Bureau should send someone here. I'm not saying that the officials here are not suitable, but I think that someone from the Bureau should be here to talk about this. On this tripartite consultative mechanism, we do have that in Hong Kong. We have a labor advisory board. I'm not a part of the LAB, but I know how they operate. In June last year, we left a meeting of the LAB and we walked out. The reason for that is because the government did not respect us and did not consult us. They bypassed the government bypassed the Labor Advisory Board. They decide on what the LAB should discuss. So is the government actually respecting the LAB? I doubt that. So we propose a motion. We need to accord a statutory position to the Labor Advisory Board and that the government should consult the LAB before coming to the LegCo.
My second point is this. As we can see from the paper, the LAB's items in the past were proposed by the government. LAB members had no formal channel to propose items for discussion. Of course, the LAB members could talk to the government and then ask the government to sort it out. Now I come to the tripartite mechanism, industry-specific tripartite bodies. Discussion happens on specific issues only. Can there be regular discussions at these tripartite bodies at the industry level? You go nowhere, things fall by the wayside when you have only issue-specific discussions. We try to talk about standard working hours. The working report got nowhere, and then the matter fell by the wayside even at the tripartite body level. So the government needs to set up a platform for employers and workers to talk, and more, the government needs to be proactive. The tripartite mechanism needs to be regularized. Does the government have any further ideas on these points? Now, the philosophical point can be left to the Deputy Commissioner, but there are other problems, statutory standing for the LAB and ways to improve the industry level tripartite bodies. Now I can address the point about LABs, and then the Assistant Commissioner can talk about the industry level tripartite bodies. We value the role played by the Labor Advisory Board. The LAB is an important and high-level tripartite body. When there are proposed changes to labor legislation, we try to reach a consensus at the LAB before the proposal comes to LegCo. We received views from LAB members. LAB members can propose items for discussion. We have had examples like that. LAB members could propose items, and then we follow up and have a discussion at LAB meetings. Now, on industry level tripartite bodies, the Assistant Commissioner can tell us more about that. Mr. Liang. Now, on the industry-specific tripartite bodies, we have 9 such bodies. They have regular meetings and events. The items for discussion depend on the views of the members of those tripartite bodies. They include trade associations, employers' bodies, and trade unions. We allow time for those members to share their thoughts on the employment situation at that time. It's a standing item at those meetings. At these industry-level tripartite bodies, the discussion helps us keep our finger on the pulse of different industries. When publicity is needed, we also work through these tripartite bodies. Thank you. Next, Ms. Lillian Kwok. Thank you, Chairman. Now we can leave the philosophical points to the Undersecretary, but I want to focus on prevention here. The government mentions early intervention. Paragraph 4 in the paper mentions inviting labor organizations, employers groups to take part in events, raising awareness, publicity, all that. Can the government share figures by inviting bodies to take part in events from time to time? How often? How many events have been held? What's the response? So that we can tell whether all that work is enough. Now, on proactive intervention, I want to share an example. I stress prevention because of this. In December 2021, 31,600 employers. In 2024, 32,800 employers received an extra levy for MPF. That means each month, more than 3,000 employers fail to keep up with their MPF contributions. I believe most employers play by the rules, and that includes Mr. Tommy Cheung. We don't want employers to break the law. Employers don't want to break the law, but some lack the awareness. I believe some of these cases have to do with small and micro firms. They struggle with calculating leave balances, long service pay, and tax filing, and work through all those deductions and handling MPF contributions. I came across a case. It took 6 years, and that employer still struggled to cancel the MPF account for a worker who had left. So can more be done on prevention on this front? Apart from the administrative tasks, I believe many disputes turn on employment contracts. Contracts can be vague, and that leads to sham self-employment. Can we have hotlines from the government? Can we have more publicity? Let those workers call the hotlines. Before these people sign the contracts, can they call the hotline to tell whether there are pitfalls in the contracts? Does the contract make sense? Can we also let employers call the hotline so that they know what to look out for in drafting the contract? Let's get things right beforehand, and then maybe we can save trouble down the road afterwards. So, prevention of labor disputes before they happen, and also MPF contribution. And maybe this is something for the MPF authority, or can the Labor Department share something with us about the MPF contributions? Thank you. On early intervention, let me see if my colleagues have statistics on that. At different times, issues like that come up. Our impression is that early intervention works. Trade unions get wind of wages in arrears or layoffs. We already have channels for engagement. So we become aware of certain situations before that matter becomes public. We may get wind that a certain company may want to lay off staff or change their contractual terms. The government may get the wind first, so we proactively follow up on that. Those cases were dealt with before the labor dispute arose. Now on MPF contributions. The MPF authority chases up employers for outstanding contributions. We do have meetings with the MPF authority. I know the MPF authority has done much work on that. The authority wants to make sure that the employers make the contributions according to the law. There has to be protection for the employees. Enhancements have been made. I can pass the message from Lillian Kwok to the MPF authority about those issues she brought up. Now, on employment status, this matter has received public attention, so we have stepped up work on this front. Dedicated websites, hotlines are there. At the Labor Relations Division, we stepped up consultation services. People can come to us when they're in doubt, and we can help them sort out whether they are an employee, they're self-employed, or they're in a bogus self-employment status. Ms. Lillian Kwok has a follow-up comment. We hope the Labor Department can coordinate the Inland Revenue Department and the Companies Registry and the MPF Authority. Can we have a hotline, one-stop service, and sort out the issues? Can that work better? A brief response from the Commissioner? No. Mr. Peter Xu. Thank you, Chairman. I support measures to foster harmonious labor relations. But there has to be a basis, and that is employers and workers need to know their rights. In the early days, when someone works or they start a business, they lack access to the information. The paper says labor groups, trade associations are involved in seminars, workshops, etc. Does the government talk to the heads of the trade associations, or is everyone in those groups invited? The same goes for trade unions. Trade union leaders know the labor laws. The issue is, how do we cascade the information to the workers? That will be more effective. There are students who have yet to join the labor market. Can we have more publicity to let students know labor rights? Doesn't matter whether they become employees or they want to start a business on their own. So early exposure of students to labor rights will help. I also agree that workers may require greater support. They may not be as well aware of rights and other matters as employers, but small and micro firms have told us there are bogus work injuries. The worker tells the boss the worker is injured. They say they have a sprain. Because sprains don't come with superficial wounds. There's just a doctor's note. When you go to a government clinic and complain of a sprain, the government clinic gives you 2 to 3 weeks leave. Even with magnetic resonance imaging, it's hard to tell how the injured person feels from the sprain. So small and micro firms have told me, of course, you grant leave to a worker who has just got injured. But then there are workers who keep getting doctor's note saying this person has a sprain, and the firm has to pay the worker for maybe 18 months, up to 18 months. But the same worker who claims work injuries actually takes on another job outside. and that's causing problems for small and micro firms. There's a growing trend of this issue. So what can be done to help these more small and micro firms?
嘅情況。
Deputy Commissioner, please. Thank you, Mr. Xu, for your question. Let me take the question on work on injury on duty, and then my colleague will take other questions. I understand that there is such a case. I don't think that is a prevalent trend. When such cases arise, I think that the employers of the small and micro enterprises can talk to our department if they suspect that there is fraudulent claims. They can talk to our colleagues, and we do have a mechanism to look into the cases and gather relevant evidence. After that, we will provide advice to the relevant employers. I will ask my colleague to talk about publicity. We invite trade unions, workers' unions to our seminars. We don't limit the scope of audience. Through publicity and education, we promote the employment ordinance so that both employers and employees know more about their rights and obligations. On amendments to existing ordinance, when we organize seminars and talks on those issues, stakeholders that are more experienced will be more interested to join. But for general introduction of employment ordinance, everyone would be interested. For students who have not yet joined the workforce, do we have any information that we can send them? For students working summer jobs, they also have to observe their rights. We do have relevant information about that. And all these information can be found on our website. On promotional leaflets and guidebooks, we try to design them in a way that is more attractive to young people so that when they are joining the workforce, they would be more interested to read those guidebooks and leaflets to know more about their rights and obligations. Mr. Xiu, please be brief. You talked about a bogus injury on duty, and you said that there was a mechanism. But then I was told that employers have to pay the salary upfront for 18 months at least, and when there is dispute that have to be handled by the court, usually the employer would be the one to lose. The employers can claim insurance, but their monthly payment of their insurance policy would increase after claiming. Mr. Chan Kin-por has raised relevant issues multiple times. I hope that you can actually follow up on that. It's my turn. First of all, just now Deputy Commissioner said that there is no strike recorded in the past 2 years, but I read the annual report of the Labor Department. In 2020, there were 5,500 people who participated in a strike. According to the report, the strike was related to the same nature. I wonder if that is about the medical officers who were asking the borders to be closed between us and the mainland. Are you referring the strike to one defined under trade unions ordinance that is an action arising from a dispute between employers and employees? My second question, you said that you proactively intervene. How do you do that? Now, the Labor Advisory Board has come to a consensus that the continuous contract is not based on 418, instead, it's based on 468. After that, the employers may change the contract and ask the employees to work 67 hours a week instead to circumvent the requirements. I think that the Labor Department would not agree to such an adjustment, but employers may try to do that. Sometimes the employees are forced to accept such an arrangement or contract. If the definition of the continuous contract is actually amended in the future, how will you intervene in such cases where the employers try to change the contract to bypass the law? Third, I understand that we have passed a convention on the tripartite consultative mechanism in Hong Kong. So do you have any measures showing that we have actually implemented the international convention in Hong Kong? Do the trade unions or workers' union have more role to play? And can we implement more international conventions in Hong Kong? Thank you. On the continuous contract issue, I will invite the Assistant Commissioner to answer that question. As for your other questions about the 2020 strike, the number of working days lost in that strike well, the strike has to do with the strike initiated by the medical officers and nurses. That has to do with the closure of boundary. Also, the workers were striking for the number of working hours and their workload and so on. So a lot of issues were involved. The strike involves dispute between employers and employees. That is why we consider the strike in 2020 a strike as defined under the Trade Unions Ordinance. As for the number 144 International Convention, we have to submit a report every year to the International Labour Convention organization on how we implement the convention. There are 3 tiers. In the top tier, there is a tripartite participation in the Labor Advisory Board. There is equal participation from the employers and employees. On the industry-based tripartite committee, we also involve both the employers and employees so that they have direct communication. There are some other examples. The minimum wage committee, we also have the participation from the trade unions, the government, the employers, employees. We also have different consultative bodies where we have participation from the government, the employers, and employees with tripartite participation. On continuous contract, would the Assistant Commissioner supplement? Thank you. Now, if the continuous contract is changed to 468, will the employers amend the contract unilaterally? Well, there are a few measures that we will take. Before the implementation of 468, we will step up publicity and education to the general members of the public, including employers and employees. We will raise awareness among members of the public about this 468 arrangement. If there are employers who amend the contract unilaterally, we do have a provisions under the employment ordinance stating that the employers cannot amend the contract without the consent of the employees. Employees can seek compensation from the employers because the employers change the contract without their consent. We also have another provision under the employment ordinance stating that the terms of contract, if they impact on the benefits or rights of the employees, the contract can be voided. If employees have any questions, we welcome them coming to the LRD for inquiries. Thank you. About the issue of strike, I hope that the Labor Department can be more clear about that. We want to strike a balance or differentiate between political strike and the strike that is defined under the trade unions ordinance. We want to differentiate between industrial action and actual strike. Now there is one more member who want to ask for the second round. I will draw the line here because we have another agenda item. Now I invite Professor Chen, 2 minutes. Please, thank you. Thank you, Chairman. How should we strike a equal partnership between employers and employees? We always ask for a partnership of the mean. As for the injury at work issue mentioned, I think that this is a serious problem. I support that we should protect the rights of the labor, but I don't think that anyone should scam the employers by falsely claiming to be injured at work. I think that the department have to strike a balance. You have to protect the employees, while you also have to protect the employers, especially small enterprise owners. As Mr. Chang said, they said that a labor department is only protecting the labor. So do you have any figures on the false claim of injury at work? And will you formulate a blacklist? Anything to add from the Deputy Commissioner? No. Thank you. Now we have to handle this motion. If we all agree to go ahead, well, Mr. Shanghai Long, do you want to speak? I've pressed for the second round. Let's handle the motion first.
If members agree to deal with this motion, I now invite the movers of this motion to read out the motion. And this is about measures to foster harmonious labor relations. Mr. Dennis Leung. Thank you, Chairman. On behalf of the FTU's 4 members, I will now discuss our motion. This shouldn't be just about employers and workers. The government should also get involved. Greater participation from the government is needed. Let's look at Singapore and South Korea. They have these tripartite models, and those models work well. So we need to enhance the functions of the Labor Advisory Board. Can the government also do some research? Can we have industry-specific tripartite models, and let's explore more issues? So that we make it easier for employers to hire people and make it easier for job seekers to land jobs, and let's also explore issues like retirement protection and pay. We need all kinds of measures to address our issues with the workforce so that workers and employers stand to gain. That's how we can enhance sense of security, sense of gain, and well-being. I hope members can support our motion. We're just asking the government to do research. So the wording of the motion is shown on the screen. Members who are not part of this panel cannot vote. Those in favor, please raise your hands. Okay, now, clerk, do you count? Those against, please raise your hands. Any abstention, please raise your hands. Can put down your hands. Can our clerk read out the result? 6 in favor, no one against, 4 abstentions. I believe those in favor are in the majority. I declare this motion passed. Will the Labor Department please take note? So that wraps up this item. We move on to the next item on the agenda, and that is latest development in the employment services. Let's invite the officials to join us. Joining us for this item are Deputy Commissioner for Labor, Mr. Raymond Hall, Assistant Commissioner for Labor, Employment Services, Ms. Jade Wong, Senior Labor Officer, Employment Services Operation, Ms. Karen Fong, and Senior Labor Officer, Greater Bay Area Youth Employment, Ms. Sharon Low. Welcome. Members who wish to speak, please press the button. Can the government walk us through the paper? Chairman, I will highlight the salient point. This item is about another key area of the Labor Department's work, employment services, that is. As members are aware, for employers and employees, the Labor Department offers diversified placement and recruitment services. At different districts, we have job centers, industry-specific recruitment centers. There are other channels. We have a popular service, interactive employment service website. There's also a mobile app, telephone employment service center. All these channels are there so that people can find jobs at different times. These services apart, we also have measures for specific groups, those middle age and those of a senior age, young people, people in the ethnic minorities, and people with disabilities. We have specific employment programs for these groups. We give support. There's also on-the-job training allowances. It's a way to encourage employers to hire different people. I want to highlight 2 employment programs in particular. First, the Greater Bay Area Youth Employment Scheme. We regularized this scheme last year. On February 15th, we launched this year's program. There are enhancements this year. So starting from this year, we do year-round application from young people. Employers can provide vacancies. We have also relaxed some arrangements. This means employers can hire young people who once worked as interns at their companies. In the past, we had a restriction. They could not hire young people who interned at their companies. But starting from this year, we remove this restriction. Another relaxation works like this. We need firms with a presence in Hong Kong and the mainland, and then we get the young people to work in the mainland cities of the GBA. But starting from this year, we give greater flexibility. The companies can approach us. During the 18-month on-the-job training, half of the time, that is 9 months, the young people can come back to Hong Kong, or they can go to other parts of the mainland GBA cities. So the young people can spend half the time in Hong Kong and then the other half in the mainland cities of the GBA. That means greater flexibility. We also have another scheme mentioned in last year's policy address. We are promoting a re-employment allowance scheme. Our target is to roll out the scheme in Q3 this year, targeting those aged 40 and above. So for someone out of a paid work in the last 3 months, and these people re-enter the labor market, they work 6 months, they get $10,000 in re-employment allowance. They work another 6 months, they get another $10,000. So in total, they get $20,000 in total in re-employment allowances. We are working full steam ahead with the preparations. We're also in touch with labor groups. We try to launch this pilot scheme in Q3 this year. So those are the highlights of our employment services. We welcome comments from members. Thank you. 8 members are lining up to speak. At 10:45, there's another meeting that will take place in this conference room, so I will give each member 3 minutes. I will be flexible with the time limit, but I also ask members to be brief in their questions. First, Mr. Peter Shiu. Thank you, Chairman. Paragraph 16. This is the support for ethnic minorities. Members of ethnic minorities matter for us, but their employment rate is on the low side. Many members of ethnic minorities can work lawfully in Hong Kong. The paper mentions vocational language workshops. They struggle to land a job because of language barriers. So for these workshops, how many people from ethnic minorities actually took part in the workshops? Paragraph 3. For those who signed up for employment services, 35,000 people, that is job seekers. But in terms of vacancies, 1.17 million private sector vacancies on these platforms. This means we have a labor crunch. That's why last year the enhanced supplementary labor scheme was rolled out. People in catering sector told me they applied for the enhanced labor import scheme and their application was granted. But others complained about the cumbersome application process. They don't bother with the red tape. We have a labor crunch in Hong Kong. So for the catering and retail sector, can we have a streamlined route? Can we have a quota for the sector for us to apply for imported workers? Deputy Commissioner. I thank Mr. Xu for his questions. First, I will address the point about imported workers, and then the Assistant Commissioner can discuss the employment of members of ethnic minorities. As Mr. Xu mentioned, the government launched industry-specific labor import schemes and also the enhanced labor import scheme. We give priority to local workers. With that in mind, we also give flexibility for employers to import workers. For the retail sector, this is covered by the enhanced labor import scheme. For common posts, cashiers, shop assistants, the work hours, pay, and job duties are more or less uniform. If employers can adopt our terms, then that will help in their application for imported labor. And then we can look at how we can further streamline the application procedure to shorten the time the processing takes. But we also have to strike a balance. While processing application for imported labor, we also need to give priority to local workers, jobs of local workers first. So we need to strike a balance. Now, on the point about ethnic minorities, the Assistant Commissioner can elaborate on that point. Thank you. We don't have the statistics on members of ethnic minorities. Now, for job seekers from EMs registered with the LD, they make up 2.7% of the total number of job seekers. Now, on the Racial Diversity Employment Program, last November, we regularized the program. We rolled out vocational language workshops. So we have been holding classes. We also step up outreach services, work through the Social Welfare Department and Home Affairs Department to reach out proactively to EM job seekers. Mr. Peter Xu, I was asking for figures. You cannot just say you have no idea how many people there are in the ethnic minorities. You cannot just say you have not maintained the figures for those workshops too. I also asked whether there will be a labor import scheme specific to the retail sector, just like what you have for the construction and transport sectors. Mr. Xu asked for figures. Can the Labor Department provide the figures, or maybe ask the Census and Statistics Department for the figures and give them to Mr. Xu, Mr. Dennis Leung, or like Mr. Kenneth Leung? On the Greater Bay Youth Employment Scheme, I can see the government has taken on board comments from members. There's liaison. Starting the scheme early, for example, and also relaxing the requirement on where the young people can work. Members' comments have been adopted. On last year's arrangement, I have some questions. This year, 718 offers were made. Some people wondered why so few. This is about the market because we need young people to apply for the jobs. But have we studied why is that we have more than 2,500 vacancies, but only 700 offers were made? So people wonder why this discrepancy. Has there been any study on whether we're not offering diverse jobs? Or is it because of a gap between the skills and expectations young people have and the jobs on offer on the other hand? Failure to resolve that gap will mean that even a pay of $20,000 per month cannot help boost the uptake. And my second point is that it's about the disadvantaged. There are students with special education needs. When these people graduate, are there programs to help these people with special educational needs land a job? These people need an appropriate, a suitable environment, and once that's in place, they can bring into play their skills and that can help our job market. Those are my two questions. Thank you.
係好。
Deputy Commissioner, please. Thank you for two questions. Let me first answer the questions on the GBA Youth Employment Scheme, and then I will invite the Assistant Commissioner to take the other questions. Mr. Leung was correct. The number of job offers is affected by a number of factors that include the economic situation and the matching situation between the jobs available and the skills of the employees. We talked to different stakeholders, including participants of the scheme and the higher institutions, along with the enterprises. We collect their views. We roll out this scheme to provide support to enterprises, and we want them to make available job offers to young people. We want to offer opportunities for young people who graduate in Hong Kong and other places. And we also offer advisory services to enterprises. The number is affected by a host of factors. We will try to work harder on that in the future. Hopefully, there will be more young people who will join the scheme in the future. Assistant Commissioner, please. Thank you for your question. On students with special education needs, we do have two schemes to help them. We have a Youth Employment and Training Program, YETP. Young people aged 15 to 24, they can join the scheme after graduating and before joining the workforce. We do not differentiate the ability of different young people. And we also have a selective placement division to help these young people. They can register with the selective placement division if they want to apply for employment. There are 66 young people with disabilities who have registered with us. Those people are with ADHD and so on, and we will try to help them find a job. Thank you. Next, Mr. Shang Kai-long. I would like to ask the administration about some numbers. There are 350,000 odd employers in Hong Kong, I believe. There are 1.17 million vacancies in the private sector. Are the numbers real? Are these vacancies actual numbers? The government said that the unemployment rate is some 2%. So are people coming through the Top Talent Pass schemes and other schemes apart from the labor force as calculated in the unemployment rate? Second, the administration has released a number of schemes, including the employment program for the elderly and middle-aged and so on, how will you encourage the immigrants who have come to Hong Kong, including the Category C worker who have come to Hong Kong through the supplementary labor scheme, to join the workforce? And do you have any scheme to encourage the enterprises to provide retraining services? Can enterprise apply for allowance from the government to offer Cantonese training courses, for example? Thank you. Deputy Commissioner. Thank you for your questions. I will try to answer them. On the unemployment rate and underemployment rate, that's the figure reached by the Census and Statistics Department. They have a set of standards and indicators, and they do household surveys. I believe that top talents and new immigrants are included in their calculation. In other words, the CNSD adopt the same standard in deciding whether a person is employed or underemployed or unemployed. We do have a top talent engage or Hong Kong talent engage. The relevant department provides advice to immigrants. Well, the number of vacancies that we set out in the paper is accurate. The validity period of each vacancy is 30 days. After some time, the employers may submit the same vacancy to our department. So there may be duplication in calculation because the same vacancy may be posted a number of times. Thank you. For the Stream C workers who come through the Top Talent Pass scheme, you may not have targeted measures to help them. We do have a meeting that we will discuss the relevant topic in the panel on manpower. Maybe we can go into that in that meeting. Thank you. Dr. Ngan, I have 4 questions. First, on district-based recruitment in Kowloon East, as the government has this EKEO, for the recruitment centers in Kowloon East, can we organize recruitment or job fairs that target local workers so that they can work in the same district where they live? Second, I would like to ask about the usage of the recruitment centers or the mobile applications by the Home Affairs Department and Labor Department. There are a number of terminals in the recruitment centers and their offices. It seems that there are not a lot of people using them. Should we maintain so many terminals in the centers? Also, I would like to ask about the employment program for the elderly and middle-aged. Should we encourage the participants of this program to join industry that are experiencing manpower crunch? My 4th question on Greater Bay Area Youth Employment Scheme. It seems that we have a consensus that we should expand the scope of participants to graduates or students of associate degree holders. Why do you not include such group of students in the scheme this year? Thank you. There are 4 parts to your questions. On the district-based recruitment centers, I will invite the senior labor officer to take that. Well, we do not limit the industry where participants of the employment program for the elderly and middle-aged can join. We only limit that the participant should not have worked in the past 3 months before joining the program. Ethnic minority persons with disabilities are eligible to join the Reemployment Allowance Pilot Scheme. As for the terminal issues, There are members who have raised similar points, and we have submitted a supplementary information on that. Terminals are there to provide one more way for people to search vacancies. We think that facilitate members of the public to look for jobs, and that is another way for them to do that. In the future, we will focus our resources on the mobile application and the interactive employment service website. We will promote those two websites and applications, but we think that we should keep the terminal just to provide another option for people. On the Greater Bay Area Youth Employment Scheme, we have considered your suggestion seriously. There are enterprises and electrical members who said that we should relax the education requirement. But this is quite a significant change. We have to look into the matter on a holistic manner. We should define the wage in accordance with the education requirement. And some members suggest that we should change the year where the students is at the higher institution. We have reviewed all these factors and we regularized the scheme last year. We have decided to keep the education requirement unchanged. On the age and the education attainment and so on, we will consider all of them because that will affect the wage level. Hopefully, after 1 year of regularizing the scheme, we will have more data and experience to work on to decide on the requirements for next year. Would the senior labor officer talk about the other issue for workers to work and live in the same district? We have a bit district-based job fairs every month in different districts. They can be industry-based, and sometimes we offer job fairs for part-time jobs. We understand that people want to work and live in the same district. So when the recruitment centers are offering job fairs, they will consolidate different jobs and they will reach out to enterprises in that district so that we can offer jobs for people who are living in that district. Thank you. The administration will consider engaging students of an associate degree in the Greater Bay Area Youth Employment Scheme. I hope that you will look into that. Thank you. Mr. Ms. Lillian Kwok. I would also like to talk about the Greater Bay Area Youth Employment Scheme. I've been talking about that since 2022. I've been asking the administration to engage students of associate degree. I hope that you will bring us good news. I have two questions about people or students with special education needs. They have difficulties in communication. Sometimes the employers are not as understanding to these people with SEN. They don't know how to leverage on their skills. In December last year, there was a tragedy. a secondary school student after graduation joined the YETP. He was worried of becoming a burden to their family. That is why they committed suicide and left us. I would like to ask how you follow up on the program. I think that is more important. You have to help these students get a job after graduation. I think that you should start helping students with SEN when they are in their senior secondary school years. I think that you should be more forward-looking because students with SEN will not have good academic results. That's for sure. EM accounts for about 8.4% in Hong Kong. Their employment rate is about 7.3%. Their employment rate is higher than local Chinese population. They face language barriers when they're trying to look for a job. I've talked to the airport authority. They want to engage people who have good English skills. The same goes for the hotel industry. But it seems that these industries are unable to reach out to at the ethnic minorities, and the ethnic minorities people are unable to look for a job. Thank you.
So the questions have to do with people with special educational needs and employment for members of ethnic minorities. The Assistant Commissioner can take the questions about those two questions. Now, on students with special educational needs, the YETP covers special schemes. Now, we do have a launch scheme. There's on-the-job training, so the company hires the worker. In this environment, there is stronger support. For someone aged over 25, the selective placement division comes in to give support. For people at senior secondary levels, we can pass the message to the relevant division to follow up the matter. Now, on people from ethnic minorities, there is the Racial Diversity Employment Program. Starting from last November, we have regularized the program featuring vocational language trainings in the form of workshops. We have commissioned non-governmental organizations. These NGOs proactively reach out to people from ethnic minorities. As Ms. Kwok mentioned, in hotels, at the airport, those NGOs promote to the potential employers, the EM job seekers out there. So I know there is promotion going on. I'm sorry, Chairman, the government did not answer my question about support from employers for people with SEN. So what has the government done to help employers? Can we get a brief response, please? Thank you, Chairman. Under the YETP Youth Employment and Training Program and also the Selective Placement Division encourage employers to provide guidance to workers with SEN, and we provide allowances too. Professor Chairman Kwong. Those employers complain about hiring difficulties. My colleague, Mr. Edwin Wong, saying that they will hire anyone. There are housewives trying to work, but they cannot make the schedule work, so they cannot work. This means much pressures workforce goes to waste, and this also holds people back from unleashing their talent. Will there be more measures to encourage firms to launch family-friendly measures so that we can get more people who are otherwise tied up because of family commitments to work? I'm pleased to see all these different programs to encourage employment. I want to focus on the employment support for this elderly and the middle-aged. How is the scheme working? What's the uptake among those old age over 60? How many people in that age group manage to land a work job? Of course, we want to see senior workers with experience to land the work, but there are age restrictions for certain occupations. So, say for drivers, we not want people of a more advanced age. So we need to ensure that the jobs match the age and the requirements of workers to avoid workplace injuries. Deputy Commissioner, I'll first address a point about getting more people to work, and then my colleague can give us the figures about the employment program for the elderly and the middle-aged. For a while, we have heard that employers are complaining of hiring difficulties. Hong Kong's labor force participation rate is also on the low side, especially among women aged over 40. This goes back to the re-employment allowance pilot scheme that we aim to launch in the third quarter this year. It's more than about the $20,000 re-employment allowance. We want to use that pilot scheme as a lever. We want to turn that into a way of bringing together different measures such as childcare, after-school childcare, etc. We also have to work on employers. Employers can offer flexible hours. Family-friendly measures are a key component. So flexible work hours and work days. So we want to use the pilot scheme on re-employment allowance scheme to get more people, especially women, to rejoin the workforce. We want to do more work on that. Ms. Fong can tell us more about the employment program for the elderly and middle-aged. In 2023, there were 3,873 eligible participants. So for an employer who hires someone aged 40 or above and provides on-the-job training, we ask the employer to provide a mentor and give the employee stable work hours. We keep reviewing the success. For those aged 60 or above, there were 1,436 such participants. So under that scheme, there were 1,436 people aged 60 or above. 3 more members are lining up to speak. After Mr. Dennis Leung asks his questions, I will draw the line. Mr. Dennis Leung. Chairman, I can see that the government is actively addressing the labor market issues in the post-COVID days. Employers are complaining about hiring difficulties. The Labor Department has many schemes, some targeted at the middle-aged, others targeted at young people, such as the YETP scheme. But the labor participation rate shows little pickup. Back in 2012, DSE takers numbered 60 to 70,000, but now it's only at 40,000 or so DSE takers. So the youth population is shrinking. But university places show no decrease. This applies to undergraduate places and associate degree places. That is 16,000 places in total. This means more DSE takers, in terms of percentage, manage to secure a place. So how can we encourage young people to take part in different sectors? Just then, Mr. Peter Shiu mentioned the retail sector. Mr. Tommy Chung mentioned the catering sector. We don't have enough workers. So what new measures are there to help young people join the different sectors? There is staff shortage in retail, in service sectors, in transport, and also in hotel room attendant. There are people who don't work after COVID. How can the government encourage more people to work? Thank you. Two more members are waiting to speak. I will extend the meeting by 15 minutes. I've drawn the line. Deputy Commissioner. Mr. Dennis Leung has brought up a broad issue. The workforce has shrunk after 3 years of COVID. This is especially the case for young people. The youth population has shrunk. They now have more options in pursuing further studies. We have programs targeting specific groups. We have general employment services as well. We will keep reviewing the situation. For areas we can strengthen in the existing programs, there's the upcoming Reemployment Allowance Pilot Scheme. We will also have a review about the youth employment schemes, such as the YETP. We will look for areas where we can improve in the youth employment schemes. When we have new ideas, we will share those with members at LegCo. Next, Mr. Michael Lok. Thank you, Chairman. A point about youth employment. Labor participation rate is only 56% for those aged 20 to 24, which is on the low side. For those aged 25 to 29, or for those in their prime, those aged 20 to 24 see a low participation rate in the labor force. These people are out of school. Why is the participation rate so low? The government needs to look into this. These are young people who have finished their studies. Why are they reluctant to join the labor market? We need to look at the difficulties they have and their motivation. Now, the youth employment and training program targets people aged 15 to 24. We need to move with the times for the age covered by this program. We call people aged 30-something as young people, so let's relax this program to cover those in their 30s. There are young people out of work for a while. Their parents want to help rebuild these people's work skills. The YETP is a good way to achieve that. So these young people are no longer covered by the YETP. They have to go to retraining instead. But the retraining courses may not work all that well. Now, the attachment training allowance is now at $7,300. That's good. Now I want to turn to the $20,000 allowance for employment program for the middle-aged and the elderly. I know the government is under financial pressure. We can have a youth edition with a slightly lower allowance. The government once gave me a response saying that young people are more competitive, so no allowance is merited. But the allowance has little to do with competitiveness of the workers. The allowance is an incentive for the workers to rejoin the workforce. That has little to do with the workers' competitiveness. Competitiveness features only in retraining. So for young people willing to work, can we get the government to provide them with incentives? Thank you.
計劃應該就係
I think that you are referring to the re-employment allowance pilot scheme instead of the employment program for the elderly and middle-aged. That is correct. Thank you. Mr. Locke's two suggestions. He asked if we can raise the age limit of the YETP. We note that and we will consider that. On the re-employment allowance pilot scheme, we think that we should roll the scheme out first, targeting people aged 40 or above. There are women who have worked before and ceased employment because of family reasons. We want to encourage this group of female to rejoin the labor force. For young people, they should look for a job after graduation. If they do not do so, there could be other reasons. We have to look for other ways to support them, perhaps. But on the re-employment allowance pilot scheme, I think that we should roll that out in the third quarter this year before we review it. We will see if we should expand the scope of targeted persons to other people. I think that we should launch it first in the third quarter, and then after some time we will review it to see if there is room for improvement. Thank you. It's my turn. In the previous meetings, there were members who are concerned about the employment situation for people with disabilities. So there is a paragraph in the paper on that. That is the employment support for job seekers with disabilities. There is a YETP that where participants are allowed to get subsidy for 9 months under the work orientation and placement scheme. If you want to encourage employers to hire persons with disabilities over the long term, you can learn from other cities and countries by providing tax incentives to employers who hire persons with disabilities. That's my first point. I would also like to ask about the application criteria for the re-employment allowance pilot scheme. I think that the requirements should be relaxed. For persons who have been unemployed for a long time, if that person landed on a job for a month and they think that the job is not suitable for them and they leave the job, in a very short time, if the employee is able to secure another job, if they don't have a long gap between jobs, I think that we should allow the relevant employees to benefit from the scheme, despite changing job a few times in a year. Because sometimes employees may try to stay on a job that is not suitable for them just to get the allowance from the government. I think that the government should relax the criteria on continuous contract. These are my two questions. Let me first answer the question on the re-employment allowance pilot scheme, and then the Assistant Commissioner will take the other questions. I agree with your suggestion. When we are working out the criteria and requirements of the scheme, we will try to be more relaxed. We have invited labor groups to discuss that. We don't foresee any problems, and we will try to address your concern and suggestion. As for the employment support for job seekers with disabilities, Assistant Commissioner will answer that question. On the work orientation and placement scheme, we have mechanism to avoid abuse by employers. Employers have to register their vacancy with us, and we do have an employment officer to follow up on that. And after the employers have recruited the persons with disabilities, we will stay in contact with them. If the employers dismiss the persons with disabilities without reasons, we will reject their application for WOPS the next time. Thank you. That concludes this agenda item. Members have put in relevant or valuable input. They want the Labor Department to be more proactive. They should not just keep their doors open and address the needs of people who come to you. The Labor Department should reach out to employers proactively to ask them to hire ethnic minorities and provide flexible working arrangement so that we can enhance the labor participation rate. Once again, thank you very much. Last agenda item, any other business? There being no AOB, the meeting is adjourned. Thank you.